not when all these technical things happen. So my 15 minutes starts now. So I'm going to make a presentation on employment law, HR, health and safety compliance, just updates for 2025. I will be going very fast because 15 minutes is quite a short time to make a proper presentation. So the things that we are going to discuss, what employers need to know and to do now, and I'm Andrew Nyamera from Tanlo Solicitors. So the overview of the 2025 legislative changes that I'm going to talk about. First, I'll talk about the legislative changes that were effective from April 2025. The major ones, that's the ones I'm going to talk about. One of them is the Neonatal Care Leave and Pay Act 2025, I beg your pardon on that one. Employment Rights Bill 2025. And that one is the major change that we need to discuss more about the ruling on the definition of a woman. You can see it updates for medium and large employers. Okay, so these are the changes that came in terms of income. You know, when people come to work for you, number one, I believe they're not coming to work for you because they like you. They're coming to work for you because they want money. And this is the minimum salaries that they're entitled to. The reason why we talk about money as lawyers, as my colleague maybe touched on in your presentation, is that when we go all over the country, when we are auditing companies, we see some companies are paying less, some are paying more, and organizations like the Home Office, the CQC, they don't like it. The HMRC, they don't like it when you pay less, you get in trouble because of that. So make sure that if your systems are not automated to update the salaries, make sure that you do it. Or if I've seen sometimes that you maybe employed someone who came from India or Zimbabwe or South Africa who is brilliant in finances or accounts, but doesn't know the law of the UK, make sure that they know what to do with the figures, because that can be issues later on. So you need to do your wage audits all the time because of the reasons that I've explained. You update your systems, you have conversations with your staff about their salaries, with supervisions and appraisals, and you review your budgets because like this year, the budget is going to go to a lot of compliance and a lot of updates that are going to happen or that are already happening. So that is quite important. And you also need to review your recruitment process and offers that you have done. If you had made an offer and you now think that in terms of income, you cannot meet the demands financially, then you might need to consider whether or not you're going to recruit or consider the contracts that your employees have already signed. Because some of the contracts, I always say to people, for a minimum, the contract should normally be 37.5 hours. And if it's not necessary, why do you give people 40 hours or more hours than that? Because in terms of cost and compliance, you're adding more to what is necessary. So in terms of statutory payments and tribunal awards, this is when your employee decides to take you to court or to go with you to ACAS because of financial issues. If you are being taken to court, for example, for tribunal awards, there has been a lot of increases. We use the vendor bans and we use a lot of calculations that are there. So if you are taken to the tribunals, there's a lot of awards that might be awarded to the employee. So the best thing is to comply with the law before you are taken to the tribunals. So for statutory payments, the SSP is now 118.75 per week. Maximum unfair dismissal is now 118,223. That's quite a lot of money. And as I will explain later, at the moment, unfair dismissal is starting at 2 years. Anyone working for a year under 2 years, they cannot raise unfair dismissal. But the Employment Rights Bill is going to be a day one event. So if someone works for you 1 day and you dismiss them, you might be liable to pay them that amount of money.
Wow.
Policy, you have to update your policies, and training for managers is quite important as well. Just updates, budget update your term rates. Employer national insurance contributions and allowances, again, those are the new figures. The threshold has been reduced. It used to be around 10,000, 9,800 or something, but now it's been reduced to 5,000. The allowance as well. So it means that you're going to, you were not contributing between, when it was 10,000, you're not now there's another 4,000 additional that you're contributing upon because the project has been reduced. Then there's the allowance and HR and finance actions that you need to do. Again, it's align payroll and finances, reassess the headcount of your employees. It's quite important because some of the things that I've seen in my own audits with companies is that because of poor systems, some people are still on payroll, or some people, some contributions are being made, or some other things even. People have got so many subscriptions. They've got, if it's a care company, they've got Care Planner, Atlas, Bed, whatever, all sort of things that they're not using and so forth. And also have to look at the allowance and update our budgets. This one is now effective. Neonatal care leave and pay. With this legislation, where an employee has had a child who is even under 28 days, because previously it was a child over 28 days, but grieving or problems when the child is 1 day, 2 days, 3 days, it can happen to every, it doesn't live to 28 days. So the law corrected that by introducing this neonatal care leave and pay, which means that any person who has had a child who's not feeling well or who has died or anything like that, they are entitled to have some leave at the expense of the employer. No, it's not unpaid leave, you have to pay them. So they are entitled to 12 weeks of leave. And they don't have to take the 12 weeks all at once. It can be spread over a period of 60 weeks. So they can take 1 day today, 2 days next week, and so forth, and you cannot refuse to give them the leave. So the eligibility is a hospital admission within 28 days from birth, 7+ days stay, and it covers both men and women. It's not only just covering the mothers. So the fathers as well are covered. So the father can also, so if the mother is on maternity, fine, the father can take paternity, but this is in addition to paternity. So it's an additional pay. What's paternity, remember, you'll be paying them as well. So this is in addition to that. So in terms of HR actions, you need to have a policy. This is a new law. So if you've got in HR some company that gives you support, make sure you get a policy for that, because it's a new law. You didn't have it, I know that. So don't think you've got it from Peninsula or Citation or TAG Law or another company before, unless if they've already given you starting from this April. And it's also important to train the HR regarding to the neonatal care and leave, and obviously the payroll to update it, to take care of that, and communicate it to your employees. Your employees might not know about it, but you've got a duty towards them to inform them that they're entitled to this leave. Because if they do not take it, later on, as an employer, you get in trouble. You have to update your handbooks. Employment Rights Bill is expected this summer now. Summer has come, guys, and more compliance has come, and more expenses have come as well. This one is a big one, and as we have started talking about this one since last year, and there's just summarized a few things there. So there is the things that will be covered by the Employment Rights Bill. Unfair dismissal becomes effective from day one. The government is going to deal away with the 0 hours contracts. And flexibility is going to be something that is offered to the employees. You cannot refuse someone flexibility for no reason. There is things to do with whistleblowing, harassment policies, and so forth. So you need to make sure that you are prepared for the Employment Rights some of the things are going to be started to be implemented in June going forward. Not everything is going to be implemented straight away, but they're going to be starting to be implemented. So if you have not had any training, it's important even as a business to start having conversations within the business regarding the employment bill, because A, there's a lot of compliance that you need to do, updating of your policies and procedures. And then B, you're going to have a lot of expenses because, like I said, dismissal is going to be on the first day. If you're using 0 hours contracts, you might not use 0 hours contracts. And if you were not offering flexibility, then you need to make sure that you're offering flexibility to your employees. You know, even in cases where you think that flexibility is not offered, you have to give reasons why you cannot offer it, and so forth. So revise your policies, whistleblowing contract training, review your contracts and so forth. So the current contracts that you have are eventually going to become redundant. So any new contracts that you will sign with your new employees then will have to cover these things. And you might have to consider making a statement of change with the current employees or an addendum to your current contracts. So I've been talking about the 0 hours contracts and form. You can cross through that. So you have to make sure that they've got secured hours, and that one employees will be happy because they go to the hospital and they are told they are not going to work tonight and they are given 1 hour, 2 hours, 3 hours. That will be a thing of the past. If they come and you don't have work, you depend on the full shift. So all those things need to be. So I'm going to talk about this one, the Supreme Court ruling on women or woman. So according on the 16th of April, there was a decision by the Supreme Court of the United Kingdom. The case had emanated from Scotland, and you remember what was happening in Scotland, women being put in the same place, and women were with trans women, and they were not able to take the case to court. Now the Supreme Court, I think in paragraph 187 of the decision, said that the definition of a woman is someone who was born naturally as a woman. So if you change your sex or you identify yourself as a trans woman, you are not regarded by law as a woman. I know this is controversial. I know people might not agree with it or might agree with it, but I'm not here to cause debate. I'm just here to say what the law says. So whichever side of the argument or debate you are on, at the moment, according to the law, a woman is someone who was born a woman. A man is someone who was born a man. So you need to look at your policies, to adjust your policies. Because I was reading yesterday, Barclays Bank, you've said trans women cannot go into toilets with women. It's not part of their policy. And I was reading again yesterday that the FA, they've also changed their law that trans women cannot play football with natural women. So you have to look at what you're going to do as a business. If you've got trans women or natural women, then if you're using maybe say shared toilets, policies and so forth, you have to look at that. That applies to men as well, trans men, whatever. So you have to look at that as well. And that's causing a lot of discomfort to people, but it's there. That's the law. So you have to update your systems, do the legislation, communicate with your staff, and so forth. I think the last one is about health and safety. Mental health risk assessments for employers with over 50 staff. If you've got more than 50 staff, you have to look at that. Employers must conduct formal risk for mental health. This includes identifying workplace stressors and offering appropriate support. So it means even yourself, you should not be the stress of your employees. Economic reviews for hybrid workers, because at the moment hybrid workers, sometimes they are just given a laptop or a tablet and a small phone, and they are told to go home and work and so on. But the government has realized that you are saying someone going to work from home and they are working from their bed or from their kitchen table or from you to assess and make sure that otherwise you're reliable. So employers must ensure that workstations are economically sound, using risk of repetitive strain injuries and musculoskeletal disorders. And then must also in the workplaces equality standards, you have to observe them because they are your HR action points. So this is the summary of my presentation, and those are the details. Thank you so much.